When exploration companies want to explore for minerals on your land, it can understandably cause concern. The Department for Energy and Mining is committed to ensuring that exploration is done responsibly and that you understand the process, your rights, and where you can get support. Explorers should establish open communication with landowners and make them aware of their rights. Explorers must observe landowner biosecurity requirements, minimise land impact, fix any damage without delay, and limit noise, dust, and other disturbances. Exploration tells explorers where minerals are found under the ground. In the first phase, known as low-impact exploration, explorers may do airborne surveys to identify geological features and analyse local soils and vegetation to search for minerals. Low-impact exploration happens over a large area and is unlikely to impact farming land at all. The second phase is called advanced exploration. Explorers take samples of below-ground rocks in smaller areas. The explorer must notify landowners about planned exploration. They can do this by sending a notice of entry form at least 42 days before entering the land, unless the landowner and company agree on a different time frame. The waiting period is designed to give you time to consider any conditions for the proposed activities and have discussions with the explorer. You do have the right to object to the explorer entering your property, as long as you do so within 3 months of receiving the notice of entry. You can lodge your objection in the Warden's Court or Environment, Resources and Development Court. Some land is exempt from exploration. In general, exempt land includes developed land like gardens, plantations, cultivated fields, orchards or airfields. It includes land within 200 and 400 metres of a house. The distance depends on the type of exploration. And land within 150 metres of an industrial or commercial structure, a spring, well, reservoir or dam. If the explorer wants to explore on exempt land, they must approach the landowner to request that they waive their land exemption. If you agree to this, you have the right to set terms and conditions you prefer for activities on your exempt land. This must be discussed directly with the explorer. If you need help with making agreements, there are guides on the Department for Energy and Mining's website. You can also contact the Landowner Information Service provided by Rural Business Support. They will help you understand your options. You can make conditions for the frequency, location, and type of activities that can happen, how the explorer must protect your land and business, and how they should minimise the inconvenience of the activities. The explorer must implement a program to restore and rehabilitate disturbed areas, comply with regulatory and legislative conditions, and meet the reasonable needs of the landowner. It's a good idea to make sure everything you agree to is in writing and signed by both you and the explorer. The Office of the Small Business Commissioner can help mediate and resolve any disputes. You're entitled to claim up to $2,500 for your legal fees relating to exempt land exploration requests. You may also negotiate compensation for short and long-term loss of income, inconvenience, loss of access to an area, any damage to property, costs of professional services like lawyers or tax specialists, and time spent dealing with other exploration-related tasks. If explorers do find minerals worth mining, they must always notify you if they plan to apply to mine.